It's important to have your documentation in proper order before you get there. Our second and last change in today's cast, your program says Alan Lenzner, but unfortunately duty has called him elsewhere. In his place we have Peter Griffin of McCarthy & McCarthy. Mr. Griffin was called to the bar in 1980. He articled with and practices with McCarthy & McCarthy in civil litigation. In addition, he finds time to lecture the litigation course for the Institute of Law Clerks. Mr. Griffin will speak to you on appeal procedures.
Thank you.
Be better on your time.
Oh, okay.
If your head moves, you'd miss it. Okay.
All right. Let's assume that having done all the things that Ian Blue suggests that your boss do in getting his application on before the master, that he's unsuccessful. Comes back with his tail between his legs and says, I've lost, what are we going to do? The next thing that you have to figure out, and he is obviously going to direct you on, is the direction in which your appeal goes, the particular forum to which it goes, the time limits in which the appeal is brought and made returnable, the various material which must be filed in support of the appeal, and ultimately the copies, types of documents, etc., which constitute that material. That is the subject matter of my lecture here today, and let's, I think, start by going to page 30 of the materials, to the appeal procedure chart, because I think that best gives a graphic outline of the route that I'm going to go, and I think you can best follow it from that material. Now let's start from the proposition that the motion which was taken was before the master. And let's take one of those rules that was glossed over by Michael Royce, which is third-party proceedings, and the fact that to commence third-party proceedings, you must do so within 10 days of delivery of the statement of defense. Now, very often that's not done, and it's necessary to apply to the master for leave to extend the time for commencement of third-party proceedings. Now, the master may do one of two things. He may say, yes, you've shown a reasonable excuse, and therefore I will extend the time. Or he may say, no, I will not extend the time. That takes us into the subject matter of what are called final or interlocutory orders. And the nature of the order determines the route of appeal. And you'll see referred to, if you look under this section, master's motion, final order, interlocutory order, it's going to determine how you go and where you go, and also the time limits in which you move. So, let's start with this proposition. An interlocutory order of the court is one which does not finally dispose of the matter. A final order, on the contrary, disposes of the litigation completely, or that part of the litigation which is the subject matter of your application. In respect of third-party proceedings, if the master says, yes, you may extend the time in which, or I will extend the time in which to file your material, commence your third-party proceedings, that is interlocutory because it does not end the third-party proceedings. If the master says, no, I will not give you the time, the third-party proceedings stop right there. They don't get commenced, and that would be a final order. Now, a further example would be an application to dismiss an action for want of prosecution. There are requirements in the rules for proceeding with your action expeditiously if you are the plaintiff. The remedy which is available to a defendant is to apply to the master for an order dismissing the action for want of prosecution, not prosecuting the action forward diligently. If the master grants the order, the action is dismissed. That is a final order because it terminates the litigation. If the master does not grant the order, it is an interlocutory order that, in other words, if he does not dismiss the action, it's an interlocutory order, and therefore the proceedings go ahead. As you see, it doesn't terminate the litigation. So let's take the circumstance where he is granted an interlocutory order. The appeal is to a single judge of the Supreme Court in motions court. Now that's been described to you already. The appeal is under Rule 514. Your notice of motion to motions court must be served within 4 days of the date of the order. And the rule says returnable within 10 days. Well, if you call up the weekly court office to make an appointment and say, I'd like my motion returnable next week, they'll laugh at you. So they say, how about March the 5th? Because that's the first date we're going to give you. And you say, what am I going to do about this rule? In practice, you can do one of two things. You can say in your notice of motion that you want an extension of time for the return of the motion, but nobody does that anymore. You just make your motion returnable on the first appointment date that they will give you from weekly court, because they're booking them a month or a month and a half down the road. So the 10 days isn't a serious requirement. The important thing is that you serve your notice of motion within 4 days of the order. Now, Ian talked about your record. I'm not going to go into that in much more detail. Your record must be filed with the court. And I've said in the material, or Alan said in the material, by 1 o'clock. I would say 1 o'clock because they put the list together and send the material across the street to the judges at 2. So you want to make sure your material's there. If your record's not there, it'll be struck off the list. And the record is the only material which will be before the judge. So it's very important now that the record be in and in time. Now, as far as a final order is concerned, the appeal is to the divisional court. The divisional court is what really is an intermediate appeal court comprising 3 judges of the Supreme Court, the High Court of Justice. 3 of the same judges at the level of the judge who would be sitting in motions court. Now, when you bring your application for appeal, when you bring your appeal to divisional court, you must serve your notice of appeal within 15 days of the date of the order complained of, and file your notice of appeal with proof of service within 10 days thereafter. Now, you don't set a date in your appeal material, in your notice of appeal, because the date is set by the registrar once the appeal is perfected. That is, all the material that I'm going to refer to is before the court. And then the registrar will call up and say, how about March the 5th? Is that all right with you? And you say, sure, that's great. And then you sit down for March the 5th and you toddle along to argue your appeal then. But once you've served and filed the notice of appeal, the next step is to prepare 2 things. The first is the appeal book. And that really is a record. It is all the material which was before the lower court. It'll be an index, your notice of appeal, the pleadings, the order appealed from, any reasons given for the order. And let me just stop there. Often what will happen is that the reasons are handwritten by the master on the back of the notice of motion below. What is generally done, what I do, is I include a copy of the handwritten endorsement plus a typed version of it, because inevitably it's like getting a prescription from a doctor. You can't read it, and the judges on appeal won't be able to read it. Sometimes you have to go back to the master and ask him to translate what he wrote so that you can actually put it in your appeal book. But it's very important that the transcribed handwritten reasons, if those are the reasons given, on the back of the notice of motion be legible to the judges on appeal. Now let me carry on. In addition to your reasons, your appeal book obviously is going to have any exhibits or evidence which is not in transcript form, that is, a typed form of the evidence given orally, and also certificates under Rule 498A. Now, Rule 498A is a fairly recent innovation which is based upon the fact that appeal courts have decided they don't want to see every bit of paper that was considered below. And what is required is within 20 days of filing your notice of appeal, you must serve a certificate saying what exhibits or evidence, if there's oral evidence involved, and this is more applicable to a trial situation, can be excluded from the appeal material. Within 10 days after receiving the appellant certificate, the respondent can either do nothing, in which case he agrees with it, or else file his own as to those portions which he thinks should be excluded. Those certificates appear in the appeal book. And that way the judges aren't faced with a mountain of material. They can cull it down because the parties can agree as to those things which are not essential to the consideration of the appeal. You may, on your first application, the motion, have had 4 different subjects which were canvassed by the master. You may only be appealing 2, so you're not going to put in the material from the other 2, because the court's going to say, why do I have to read all that stuff? And you can imagine when they get wading through that stuff and realize it's not germane to the appeal, that the guy who's standing in front of them next week arguing the appeal is going to get some flack. Now, you also file an appellant's statement, and that is in the form described by Ian to you previously, and both the appellant's statement and the appeal book should be filed within 30 days of setting down the appeal. Now, to the divisional court, you want 3 copies of each. For the court, 1 for yourself, obviously, and 1 for each of your opponents. The covers are all buff. Once you have filed that material, and only then, is the appeal placed on the list. And then it clicks up the list, and the registrar of the divisional court will make that call when you get close to the top of the list to arrange a date for when your appeal is actually going to be heard. The respondent's statement, again a statement of fact and law, should be filed within 14 days of the receipt of the appellant's statement, and again the covers are buff. Now, in addition to the master's motion, a similar route is involved in both cases where your appeal is from a decision of a county court judge. If your order is final, you go straight to the divisional court in the same manner and with the same material as in an appeal from the master. If your order is interlocutory, you go to motions court to a Supreme Court judge, and again the same material. Now, let's say your order, your application to appeal the master, allowing an extension of the time in which to commence your third-party proceedings, has gone to a motions court judge. The appeal from the master has been argued. The Supreme Court judge can do 2 things. He can allow the appeal and say, no, you can't commence your third-party proceedings, in which case that's a final order, or else he can dismiss the appeal and leave another interlocutory order in place, which still allows you to go ahead with your third-party proceedings. That, again, governs the route in which your particular appeal will go. If your order is final, you serve a notice of appeal within 15 days of the order to the divisional court. And you file on the appeal similar material to that which I've referred to in the order from the master, final order. That is, you're going to have an appeal book and you're going to have a memorandum of fact and law, appellant's statement it's called. If your order is interlocutory, then you may only go to the divisional court with leave of another judge in motions court, not the judge who heard the application. And you make your application returnable within 7 days of the order before another judge in motions court. Now that's a little more difficult because often you can't get on within 7 days and you have to use the same routine as I've described with getting an appeal on from the master. Generally speaking, I think you have to be a bit more cautious and you try and have the consent of the other side to extend the time for the return of that motion, unless you can find a judge who's willing to hear you. Now, on an application for leave to appeal to the divisional court from an interlocutory order of a high court judge in motions court, you need a record, same type of record that I've referred to when you're coming up from the master, except of course you're going to have to add your notice of application for leave to appeal, plus the decision, the order, and any reasons of the judge in high court, motions court, from whom you're seeking leave to appeal. You also should file a memorandum of fact and law, again with the same sort of contents as we discussed previously. These appeals are limited by the rules of practice as to whether they're going to be granted or not, really to questions of significant importance or where there are competing decisions of the same level of court on the same point, and they have to be cleared up by the divisional court. If you're successful, you serve your notice of appeal within 7 days after the order granting leave to appeal, and your appellant's statement and appeal book 7 days thereafter. And thereafter it proceeds as an ordinary appeal to the divisional court. If you're unsuccessful, that's the end of the road. No farther. You can go no further. Now, the divisional court, as I've described, is a court of limited or intermediate appellant jurisdiction. And accordingly, let's see if I lost this thing. The route of appeal, although it is to the Court of Appeal, is only with leave of the Court of Appeal, and that's pursuant to Rule 499B. Now, if your decision in the divisional court is one which you seek to appeal to the Court of Appeal, you bring an application by way of notice of application for leave to appeal. It has to be served on all parties involved in the action within 15 days of the order complained of and returnable within 30. Now, our Court of Appeal hears applications for leave to appeal usually on the first and third Monday of every month. And so you make arrangements through the Registrar of the Court of Appeal for a date and time for the hearing, or for the date of hearing your application. They all proceed first thing in the morning. And you then prepare a leave to appeal book. The leave to appeal book is like an appeal book. It's going to contain your notice of application for leave to appeal, the order from which you're appealing, any reasons, the proceedings below that, and the exhibits and like material as previously described in another appeal book. You also prepare an applicant statement, because this is an application, and you file 5 copies of both the leave to appeal book and the applicant statement by the prior Thursday before the Monday of the motion. The applicant statement is just like an appellant statement, but because this is an application for leave to appeal, you refer to yourself as the applicant. If the Court of Appeal, which of course is the senior appellate court in this province, sitting with 3 judges generally, and certainly only 3 judges on an application for leave to appeal, refuses the application for leave to appeal, that's the end of the road. You go no further. If the application for leave to appeal is allowed, you must serve your notice of appeal and file it within 7 days thereof, and then file your appeal book and appellant statement, 5 copies of each, within 15 days thereafter. And again, that material has buff covers. And your respondent statement must follow on that. Now, to this point, I've been dealing with what would be the appeal route following various motions either to the master or to the county court or a motion to the Supreme Court judge. Most of the appeals which you may be involved with are appeals following on judgments at trial. That is, parties get the action all the way to trial, the evidence goes in, arguments heard, and judge gives judgment for or against the plaintiff. Now, in judgments at trial from both the county court and the Supreme Court, your appeal is straight to the Court of Appeal. And it's by way of notice of appeal, served within 15 days of the date of the judgment, and filed within 10 days after the date of service. Now, the first step in proceeding to prepare your appeal materials from a judgment at trial is to serve one of the certificates, if you're acting for the appellant, under Rule 498A. And this is where it's very important, because in a lengthy trial, there may have been 15, 20 witnesses, some of whose evidence is germane to the issues on the appeal, and some evidence really is not. Likewise, there may be substantial exhibits, which the court really doesn't need to consider because those issues are not really involved in the appeal. So you're going to say, if you've seen the certificate or ever completed one, that we feel that the following evidence or exhibits are not required for the issues on appeal. That's sent to the other side, and thereafter, if there's a response or no response, whatever, it determines what evidence is going to be ordered, and then that's going to govern the evidence which you ask the reporter to transcribe. And that's the second step, because you must order the evidence from the court reporter within 30 days of setting down or filing the notice of appeal. And you must file the reporter's certificate, which routinely comes back from the reporter, certifying that the evidence has been ordered. Now, once you've done that, your appeal book and your memorandum of fact and law must be filed 30 days thereafter, or within 15 days after the completion of the evidence, or the later of the two, because obviously if you've got a lengthy trial, you're not going to get your evidence back in 30 days. Now, your appeal book will contain the usual index, the notice of appeal, any pleadings, the judgment appealed from, the reasons for judgment if there are any exhibits which have not been excluded by consent of the parties under the certificates, which I've referred to before, any evidence not transcribed by a reporter, and the certificates under Rule 498A. The actual transcribed evidence won't go into the appeal book. It is bound by the court reporters in red volumes and is filed directly, and it doesn't form any part of your appeal book. Thereafter, of course, at the same time, you must prepare your appellant's statement, and 5 copies of each must be filed with the court. I notice that Mr. Lenzner in his materials has referred to the fact that 7 copies must be filed. I know that Alan, in his practice, likes to make sure that everywhere the judge turns, he's got copies of his material, but 2 more than necessary is set out here. It should be 5, and I know he apologizes for that error. He hasn't told me that, but I'll tell him that on Monday. Now, the respondent's statement, again bound in buff, must be filed with the court by the 20th day of the month before the hearing of the appeal. Now, one further thing has to be done on an appeal like this, which people often forget. You have to praecipy the record from the court below. That is, all the exhibits and the material that was heard in the court below must go over to the Court of Appeal office, because your appeal will not be set down on the list until that material is received. You must remember to do that, otherwise your appeal will not be perfected. And if it's not perfected, it won't be set down on the list. It takes long enough to get a case to the top of the Court of Appeal or Divisional Court list, and you mustn't let much time go by. Now, your boss will win the appeal, so the rest of what I'm going to tell you is academic. Let's suppose you're acting for the schmuck on the other side who lost. Where do you go from the Court of Appeal? Only one place to go, Supreme Court of Canada. All appeals to the Supreme Court of Canada are by leave of either the Court of Appeal of the province in which you're practicing, Ontario, of course, or the Supreme Court of Canada itself. You may go back to the Court of Appeal and seek leave of that court within 60 days of the order complained of, by way of a notice of a motion for leave to appeal. You put in a leave to appeal book and an applicant's statement, 5 copies of each. And I think Mr. Lenzner again is going to have to acknowledge another one of his errors here. It says in the material on page 29 that the leave to appeal book to the Court of Appeal should be gray in color. That's about halfway down that first paragraph. It's buff in the Court of Appeal. It's gray in the Supreme Court of Canada. If I'm looking at 6 lines up from the bottom of the first paragraph, it says in gray color, it should be buff. Now, if one applies for leave to appeal to the Supreme Court of Canada, your application must be returnable, served and returnable within 90 days of the order complained of. You must file 10 copies of a leave to appeal book and 10 copies of an applicant's statement, which are gray in color. No respondent statement is required. Generally speaking, when you get to the Supreme Court of Canada, a respondent will file a respondent statement, and it is green. The covers are green in color. If one is successful on the application for leave to appeal, either from the Court of Appeal or the Supreme Court of Canada, because either can grant leave, you must serve and file your appeal books, 20 copies, within 30 days of the order granting leave, and 20 copies thereafter of an appellant's statement, and after that, the respondent has 15 days in which to file 20 copies of a respondent statement in green. All the appellant's material is in gray. Now, don't ask me what the Supreme Court of Canada does with the 20 copies that they have, because the maximum number of judges who can sit on an appeal is 9. That's the full court. However, they got lots of copies, and they obviously subscribe to the Lenzner principle, the more the merrier. Now, let me just deal with a couple of small matters. The difference between applicant and appellant. You only use the word applicant for applicant statement, or on your style of cause, the word applicant, if it's an application for leave to appeal. And I'm talking strictly appeals. Don't let me tread into the area that Ian Blue was talking on. Where it's an application for leave to appeal, you have an applicant and a respondent. Where it's an appeal, either leave has been granted or it's an appeal as of right, it's appellant and respondent. Your style of cause, except in the Supreme Court of Canada, never changes in order. Look at page 68 on the materials. I'm borrowing somebody else's materials because they're so helpful. You'll see there's a judgment there between the plaintiff John Allen Jay and the defendant Daniel Green. If Daniel Green, against whom judgment is awarded, appeals, he still stays on the bottom. But underneath defendant, you put appellant in brackets, and underneath plaintiff, you put respondent in brackets. And that if it's an application for leave to appeal, it would be applicant in brackets under the name defendant and respondent under the name plaintiff. You never reverse the parties depending on who's appealing, except in the Supreme Court of Canada, where the appellant's name goes first. And that's the only time that the style of cause may be reversed. Otherwise, you never reverse the style of cause in our court. Finally, judgments and orders. What's the difference? Well, it should be simple, but it really isn't. But let me give you the best view of it that I can take. In any trial, what results is a judgment. The divisional court and the court of appeal only give orders. They do not give judgments. The master and the county court judge on motions will only give orders unless they are granting judgment on a specially endorsed writ. Other than that, everything that a master or a county court judge does on a motion is an order. Now, very often, people get the two confused. That's probably the best yardstick that I can give you on the two. Remember, if you're coming from a motion or an order of the divisional court or the court of appeal, it is generally an order. From trials will always be a judgment, and given your specially endorsed writ procedure, which I'm sure all of you are familiar with, or if you're not, you surely will be very shortly, it's going to be a judgment there. But other than that, you're usually dealing with an order. Now, I don't think there's anything I can usefully add now to appeal procedure, and I'll put you into the hands of somebody else.
Thank you very much, Mr. Griffin. I'm sure the light is beginning to shine now on what we're doing in the law offices. Our next speaker is Frank Bennett, who's going to talk to you about effective collection after judgment. Now, hopefully, you'll tell us how to get some money out of defendants before they become deadbeats. Mr. Bennett was called to the bar in 1970. He's a managing partner with the law firm of Harry's Hauser. He's head of the section in the bar admission course on debtor-creditor rights and also a lecturer in bar admission course on real property. I'd like at this time to call Mr. Frank Bennett.
Thanks. I'm going to try to keep the next half hour or so simple. I appreciate you've already had a number of lectures, and by now you're probably tired of numbers and forms. Collection procedure is a lot of fun, especially if you win. If you lose, you try it on the next person. And eventually, when you get the technique down, you do win most of the times. I'd like to spend a few minutes on collection procedure before you get your judgment. Default judgment is usually a type of judgment where you can obtain default where the defendant doesn't appear or doesn't do something that the rules require him to do. And so the plaintiff can sign default judgment, mechanically sign, go up to the court office and obtain a default judgment, or under certain conditions he can move and obtain default judgment. But collections are usually based on simple procedures, and they're usually commenced by a writ of summons, and the writ of summons is called a specially endorsed writ of summons, as opposed to a generally endorsed writ of summons. Does everybody know what a specially endorsed writ of summons is? Hands up, please. Oh, good. It's a good selection. The special endorsement is used, obviously, for simple cases where the debt is easy to calculate. There's a contract, NSF check, and full particulars are set out in the specially endorsed writ. And as you've known, or those who prepared specially endorsed writs, there is a rule in the rules of practice in Chitty, Rule 33, and it sets out the various categories where you can sue. There's also a form, and the forms are at the back of Chitty, and Form 8 is your form for specially endorsed writs. I would strongly recommend that every time you do a specially endorsed writ, that you look at the forms, and if you can follow them almost to the T, do so, because the forms are there for that purpose. Once you vary a form, then you could be in trouble. Well, the writ is usually served on the defendant. It can be served on him personally. The sheriff or a process server takes the writ of summons and serves him at his home or his office. Where the defendant has a lawyer, the lawyer can accept service on behalf of the defendant. That's an acceptance of service as opposed to an admission of service, which I think most of you are familiar with. So an acceptance of service is where the solicitor on behalf of the defendant accepts the service of the writ of summons. Sometimes you get a defendant who avoids service, and it is necessary to obtain an order for substitutional service. Substitutional, usually by mail, and it's usually registered mail and prepaid ordinary mail. So that way it comes to the attention of the debtor, and the order provides that the debtor-defendant is deemed to be served after so many days. Well, if the defendant doesn't do anything, then you can sign default judgment, and the mechanics are set out in your materials. If the defendant says, "I dispute the debt," then he has a duty to file an appearance and an affidavit of merits. And the affidavit of merits effectively says, "Yes, I entered into that contract, but no, I do not owe that money. I have a set-off, I have an argument against the services performed or materials supplied. I do not owe all that money." And then you're into a lengthier process of how to end up with a default judgment. At the same time, assuming that the defendant doesn't defend, you obviously have a bill of costs. Now, that's the costs that are incurred by the client, the plaintiff. And there's a tariff prescribing how much you can get and for what items. And that's set out in your materials as well. What you do after you obtain the default judgment is praecipe, or effectively request or demand, a writ of fieri facias. Now, that's Latin for effectively a writ of execution directing the sheriff of the county court or district court to go out and levy, to go out and seize the goods and chattels of the defendant. The defendant now is our debtor, and we no longer talk, like in previous lectures, about plaintiff and defendant. We're now at creditor and debtor. And the object of the game, of course, is to collect the money that's owing to the creditor. At the same time, you're going to send a letter to the sheriff enclosing the writ of execution, and where the debtor owns property, to your knowledge or to your client's knowledge, in some other county, you're going to ask for a second writ of execution. And the second writ of execution is merely a duplicate, and it goes to that sheriff in that county or district. So you can have several all over the province of Ontario. Before we pass into effective collection techniques, I do want to cover the type of endorsement, which is somewhat confusing today even to practitioners. If you turn to page 48 of the materials, you will see a specially endorsed writ of summons, the second page of it, and you will see a claim for $4,000. A couple of years ago, the Judicature Act was amended, and the Judicature Act was amended to provide for interest at the prime rate. And the difficulty was that interest rates 2 or 3 years ago started fluctuating up and down, mostly up. The difficulty was that a person could claim interest, and the interest would be very low, and then the Judicature Act now recognized the interest rates at a much higher rate, or more in accordance with the prime rate as charged to the Chartered Banks of Canada. So effectively, you get two types of situations in a specially endorsed writ of summons for interest. And I would ask you to note this, because when it comes up, often the solicitor involved in doing the endorsement forgets about the interest claim, or forgets to do it properly in the special endorsement. And one of the defense techniques of a defendant debtor is to move to strike it out, to say it's not good enough. Go back and do your homework and do it again. And if you have to do it more than twice, it's likely that the special endorsement will be struck out altogether, and then you're into a generally endorsed writ of summons, and the collection procedure is delayed approximately 2 years in Toronto, if not longer. You'll see on page 48 two claims of interest. The first claim is in the second last paragraph. Plaintiff claims interest on the amount outstanding from time to time, from April 30th, that's when the account was due, to the date of the writ, in accordance with the Judicature Act. And he spells out the rate at 16%, which was the rate at that time. The difficulty is you spell out the rate then, that's the pre-judgment rate, or pre-date of the writ rate. It's before you issue the writ, you have a rate of interest, and then from the date of the writ to the date of payment or judgment is a different rate, or maybe a different rate. And that's the last clause. The plaintiff also claims interest on the total sum owing from the date of this writ to the date of payment or judgment in accordance with the provisions of the Judicature Act. Please note that the specific rate is not spelled out. There have been a number of cases, and quite frankly, they're screwy. That's what the Judicature Act says. One says you put in the amount before, and the cases say you don't after. So please be careful when you claim interest as against a defendant debtor. You will also note at the bottom of page 48 that I have an asterisk there, that if the judgment is delayed, there is a default judgment, and it is delayed for several months for whatever reason, the post-judgment rate may be different from the interest rate prior to the writ, different from the rate of interest between the date of the writ and the date of judgment. So you could conceptually end up with different rates all the way through. And that can be a difficult problem in calculating the amount owing to the plaintiff creditor. Let's turn to page 53. That's the writ of execution. At this point in time, you're merely a judgment creditor. And quite frankly, a judgment creditor doesn't mean very much. It means only that the defendant debtor owes the plaintiff creditor a sum of money. No one knows about it. There's no third party or record showing the judgment. There's no search record for it. What you have to do is obtain a writ of execution through the praecipe order and then file it. When you file it, you become an execution creditor, and the whole world knows about it, because when they search the debtor's name, out it comes. Please note, if the execution is filed with the sheriff's office It automatically binds the lands that the debtor may own. If the debtor owns a home or a cottage, the writ attaches to the interest of the debtor in the home at the time of filing. As you may know, if you've done any little real estate, there are two registry systems in Ontario. One is under the Registry Act and one is under Land Titles Act. When you send the letter to the sheriff and you file the writ with the sheriff, the lands under the Registry Act are automatically bound, but the lands under land titles are not. So you must ask the sheriff to send a copy of the writ to the land registrar under land titles. That's very important. Lands are bound when they're filed. Personal property is not bound at all. You have to send the sheriff out. You have to send the sheriff out to collect the debt from the debtor. And how do you do that? Well, effectively, you just send a letter to the sheriff saying, please find enclosed a photocopy of the judgment, the writ of execution, the debtor lives at so-and-so, please go and seize. What are you going to direct the sheriff to seize? This is where, I suppose, a little homework, and you have to become somewhat of a private detective. You have to find out what the debtor owes and owns. If you don't know, of course, then you're going to have to do subsequent collection methods, namely a judgment debtor examination. If you do know, then you can have the sheriff, and it's simply a letter to the sheriff saying, go seize whatever it is. And the sheriff will do that when you pay him a sum of money to cover his fees and indemnify him just in case the property is not owned by the debtor. The writ of execution. It's good for 6 years once you file it. And you should confirm the date of filing, because that's when the clock runs. You send a letter to the sheriff and you say, please find enclosed the writ of execution. Would you please advise, and there's a form in here, would you please advise when the writ of execution was filed with your office? Because that's when the 6 years runs. So you can have a judgment, say, yesterday, January 28, 1983, but until you file it with the sheriff's office, the 6 years doesn't run. So you can file the writ of execution, say, in February or March, that's when your 6 years runs. So it's important to learn the date that the writ of execution was filed. After the 6 years, you can renew the writ for another 6 years. And the sheriff's office usually advises the solicitor for the plaintiff a couple of months ahead of time. It costs today $12. A few years ago it cost a couple of dollars less, and presumably 6 years from now it'll cost $15 or so. It's very cheap, it's very inexpensive to preserve a judgment obtained against a defendant debtor, especially after a trial. Judgments after trial, page 68. That's the one that was referred to in the last half hour or so. Please note that there is a variation in the recital. This action coming on for trial, whatever the day is, and usually they're 2 to 3 years after the whole procedure has been started. Sometimes the judge will reserve the case, reserve the giving the decision, and the judgment will come out later. And there's the alternative clause for the reservation of the judgment. And then it's a simple order or judgment. This court doth order and adjudge the plaintiff do recover from the defendant the sum of whatever it is. The difference between a judgment after trial and a default judgment is the second clause, and it is ordered that and adjudged that the defendant do pay the plaintiff his cost of the action forthwith after taxation. So the plaintiff now has to go through a taxation. He doesn't get his costs automatically. In the meantime, you've got your judgment. You should register the judgment immediately and obtain the writ of execution and file it with the sheriff's office. At least you have a judgment for a certain dollar, and the enforcement technique and collection procedures can be enforced from that time on, notwithstanding that the taxation of costs may be several months down the road. Judgments today, as in this judgment, there is a stamp or it's typed on. This judgment bears the interest rate, bears interest at the prime rate of blank percent, which in November of '82 was 18%. So it can change, and it can be very effective, especially when the interest rates are high, to obtain judgments at the right time, because a debtor, now defendant, or defendant now debtor, will be paying substantially much more than he would if he had settled earlier. So the interest rate is very important now. Taxation of costs. And there is a procedural memo given to you, along with the earlier one for default judgments on page 70, little a. The procedure for obtaining costs or taxation of costs is effectively a procedure to show the court or the taxing master what you did in this whole lawsuit. And if you look at page 71, it's in effect a mini-trial as to what happened. You instituted the lawsuit, whether it be general or special endorsement. You had a cross-examine on an affidavit of merits. The defendant disputed. There were pleadings. You lost. So there has to be a statement of claim and a statement of defense, and maybe there was a reply and jointer of issue. There were examinations for discoveries, and you set out the dates, preparation, counsel fee of both sides, plaintiff and defendant, and the costs on the right-hand side. There is a record, that's that record book, an entry for trial, and then you have the trial, counsel fee, preparation, law clerk, law student, notices, subpoenae, correspondence, brief, and you set out the times. So as you see, it's a mini-trial to tell the taxing master what has happened. And if you turn it over the page, you see also the judgment and the actual attendance before the taxing master, the taxation of costs showing at $50. Disbursements, that's your out-of-pocket money, of course, that the client had to put out, or your own office had to put out in going through this exercise. And those are all the types of disbursements that you're likely to find in a collection lawsuit: issuing the writ, serving the appointment for the cross-examination, special examiner's costs for the transcripts, setting down the action, issuing the subpoena, and they all add up to $590. You move it over to the right-hand side, and then there is a taxation at that amount or such lesser amount as the taxing officer may award. That itself ends up in a writ of execution. So the taxing certificate is a judgment in effect, and you can obtain a writ of execution. So please note that with any one case, you can end up with two writs of executions for the simple debt and the taxation of costs. Page 75 is a letter addressed to the solicitor for the debtor. And it's a simple letter saying, please find enclosed the judgment. Would you please have your client pay the amount? If there is no solicitor, then I recommend that a copy of the judgment be sent directly to the debtor so that he is aware that judgment has been taken out against him. Assuming that goes well and you have judgment, the next thing, of course, is to collect it. If you don't know the assets that the debtor has, then you've got to find out. And there is a process called a judgment debtor examination. And that process involves sitting down with the debtor in a special examiner's room, taken under oath, whereby you can ask all questions relating to the property and assets of the debtor since the time that the debt was incurred. The difficulty, as some of you can appreciate, is that you serve these appointments, one appointment on page 77, and the debtor either doesn't show up, or he does show up and he refuses to answer, or he shows up and he doesn't have any documentation. Well, those are all grounds for committal. Committal, throwing him into jail. And I have given you some precedents covering that. Page 79 is the typical certificate of non-attendance. The debtor does not show up, and all the special examiner is doing is saying, so-and-so attended from the office of the creditor, the plaintiff. The debtor didn't show up. We waited for half an hour, and that is good for an affidavit in support of a motion to commit the debtor to jail, which is on page 80, and that is your motion to commit him to jail. And the affidavit in support is by the solicitor of the plaintiff, reciting the judgment, reciting the appointment by the special examiner, instructing the law clerk to attend, and there is no show, and attaching a certificate of non-attendance. A nice, easy case to obtain an order to commit someone to jail. Well, the courts are very reluctant to commit someone to jail on the first occasion. So they're not going to do it so readily unless there is a flagrant abuse of the judicial process. More than often, if the debtor does not show up on the first time, there will be an order requiring the debtor to reattend at his own expense. And that is what paragraph 1 is all about of the order on page 83. However, there are some judges who take a tough line, and if you're lucky on the first time, you might be able to get a provision in the order requiring that the debtor attend, and if he doesn't attend, then the creditor can apply to the court unilaterally, or what we call ex parte, all by himself, without notice to the debtor, and obtain such an order, putting him into jail. And I've given you a sample clause. The plaintiff will have the right to apply ex parte for an order that the judgment debtor be committed to jail for 3 days for contempt for failure to so attend. Now, quite frankly, putting a debtor into jail doesn't do anything for your client. You're not going to get anything from it. All you're going to do is antagonize the debtor. So you have to temper the wind, so to speak. You're really after the debtor's money. You're not after a vengeance to put him in jail. However, in the right case, you may not have any choice. Page 85 is a nice sample reporting letter. And a reporting letter, unlike real estate, which runs 6-7 pages, this is a simple letter saying what you did. It's nice to have on file, it's nice for the client, and effectively sets out everything. You reflect the issuance of the writ of summons, the date of the judgment, the percentage or interest rate that you got, costs, and then you go on to say that you attempted to serve him with a judgment debtor examination. He didn't show up, or he did show up and didn't have proper records, and then you're given instructions to bring an application to commit him to the common jail. One of the things in the sample reporting letter includes the obtaining of a certificate of a nulla bona. How many have been involved in obtaining a certificate of nulla bona? Not very many. It is a beautiful certificate used in the enforcement of collection of judgment from judgment debtors. There is a rule under the rules of practice that when you send the sheriff out to a debtor's residence or office, and the sheriff asks the debtor, do you have anything to pay the creditor? And the debtor invariably says, don't bother me, I don't have anything and I don't know anything. So the sheriff reports this back to the creditor, and the creditor says, well, what do we do next? Well, we should have a judgment debtor examination, if not, do it right away. And at the same time, you ask the sheriff to give you a certificate of nulla bona, and that is a certificate saying that the debtor does not have anything to satisfy the debt. And if there's nothing to satisfy the debt, then you are in a position to enforce the collection in a different way. One way, as we'll see a little later, is that certificate is used as a nice, clean, official act of bankruptcy, and the creditor, in the right case, will put the debtor into bankruptcy. So where you can obtain a certificate of nulla bona, it's only good for 6 months. A certificate is also necessary if the debtor owns lands. You will require, before the sheriff will sell lands of the debtor, to obtain a certificate of nulla bona. And that certificate is prima facie, or at first blush, that the debtor has nothing, and therefore you are entitled to sell lands. So the certificate is important for those two reasons. If the debtor pays, then the debtor is entitled to a satisfaction piece, and that is set out in page 87. It is not common practice to obtain a satisfaction piece today. It is an old-fashioned way of saying, I have satisfied the debt, thank you very much, give me back my judgment, and make sure that the record is clean with the sheriff's office. Today, what is normally done is a release, and that's on the next page, 89. And the release is simply in consideration of the sum of $2,200, which may be a sum less than the judgment. Maybe a sum less than the judgment. The creditor does release the debtor from everything, including the cause of action or the judgment that was obtained in satisfaction of the debt. At the same time, the debtor will ask for a letter directed to the sheriff's office lifting the writ of execution. So the writ of execution will no longer be on record, and therefore the debtor's name will be clear again. Page 90 is a Section 20 notice under the PPSA. How many people know about the PPSA? Everybody's learning about the PPSA. Good. This is a beautiful remedy afforded to an execution creditor before he instructs the sheriff to seize something that may belong to someone else. The Personal Property Security Act effectively covers most types of personal property in the province of Ontario. And in order for a creditor to protect himself against execution creditors and others, he has to register under the PPSA registry system. As an execution creditor, you have a right to send him this type of notice saying that you are an execution creditor. You want to see his security agreement to make sure that he has a proper security agreement. You want to check it out with the registration, and you want to make sure that it's all prim and proper, because if it isn't, then you can be in a position to knock it out. And if you knock it out, the execution creditor's rights will rise over the secured creditor's rights. I think I've confused some people here. If you have a mortgage, instead of against land, have a mortgage against chattels in your house, furniture and furnishings, and you give a chattel mortgage to a bank for a loan, if the bank fouls it up, the bank botches it up, bad security agreement, then you, acting as a solicitor for the execution creditor, have a right to knock it out. And if you knock it out, the bank loses its priority. It loses its security against the household furnishings. Then you can direct the sheriff to seize those assets without the bank's intervention. So that's why the notice is very important. One of the first things you do when you obtain judgment is do a PPSA search. You get a massive printout or a very skinny one. And if you see security interest registered, and you type out a notice just like this, and you send it out with the $4, and when it comes back, you will know who has what against the debtor. In many cases, however, your debtor is going to go bankrupt. and page 91 shows you a proof of claim that's used. Paragraph 3 is an important paragraph. It provides on page 91 that the debtor was at the date of bankruptcy, whatever the date is, indebted to the creditor in the sum of $4,267.18. Please note, it is necessary, as you'll see on the next page, to set out a statement of account. And it is usually done by just simply photocopying the judgment and attaching it to the proof of claim. Paragraph 4 of the proof of claim, in most cases, if not all, an execution creditor has no higher rights, has no priority, is just an ordinary creditor in a bankruptcy situation. So you don't get bonus marks for good efforts in getting a judgment when the debtor goes belly up. All you've done is spent your client's money, and unfortunately you're in no different position than if you were to just issue the writ and get defended or have the lawsuit defended. It doesn't give you any bonus marks. If you seize and sell before bankruptcy, yes. Then you're paid out and nobody can claim priority over you. On page 92, there's two ways to go bankrupt, as some of you may know. One of the ways, of course, is doing it yourself, voluntarily, and that's an assignment. And when you file the assignment, that is the date of bankruptcy with the official receiver. When you file the documents, the official receiver puts on a seal, and it says that whatever the date is, that is the date of bankruptcy. But if somebody does it to you, that's a petition for a receiving order. It's not until the receiving order is made is the debtor bankrupt. And there's a peculiar section in the Bankruptcy Act that says the date of bankruptcy is not when the court says you're bankrupt. It goes back to the date of the petition. So you could have 6 months, a year, even longer at times. And the date of bankruptcy will be the date of the petition. So one of the things you should find out when you file a proof of claim is, was it done voluntarily? If so, it's the date of the assignment. If it